Hey law nerds, this is Professor Tracy from Law Simply Explained back with another lesson, this one on illusory promises. And our goal this time is to look at whether an illusory promise satisfies the element of consideration. So an illusory promise is what it sounds right. It is something that purports to be a promise. It looks kind of like a promise, but in fact, the promisor is not making a real commitment, is incurring no real obligation, and therefore, whether it's the original promisor or the promisee making the illusory promise back to the original promisor, it's not going to work to supply consideration. The promise will not be inducing a detriment, either because there wasn't a promise to begin with, because it was illusory, or the promise is not inducing any real detriment because the alleged return promise is in fact illusory. So let's look at why that is. So the restatement here, section 77, gives us a definition of an illusory promise. It is telling us, kind of stated in the negative, so it's a little bit odd in its phrasing because it's stated in the negative and then it has an exception. So it tells us that a promise or an apparent promise is not consideration if by its terms the promisor or purported promisor reserves a choice of alternative performances. Okay? Unless, here's the exception, each of the alternative performances would have been consideration if it alone had been bargained for. So let's chunk that into elements. So the first being that we have to have an apparent promise, that the promisor is purporting to make an actual promise. And we're told, well, it's not going to be consideration if what? Our second element, there's a reservation of alternative performances, that the promisor is saying, well, I could do this, I could do that, unless, right, our final element here is, well, if each of the alternatives would satisfy the element of consideration, then it's fine. So we can look at those elements as the promisor purports to make a promise, the promisor is reserving a choice of alternative performances, and we have to ask, well, do all those alternatives that have been reserved satisfy the element of consideration? For us to call it illusory and therefore not work as consideration, it must be the case that they don't all satisfy the element of consideration. So let's look at an example. Bob, my house is looking shabby. I will pay you $5,000 if you will paint the exterior of my house in the next month. So Barb's promised to pay him $5,000. She's looking for him to commit to paint it over the next month. Bob says, sure, Barb, I will paint your house for $5,000 if I decide to do so in the next month. So what is that Bob's doing there? Because he said, sure, I'll do it. So he's trying to make it look like he's committing to do it, but he's also said, if I decide to do so. So if we're looking as, well, that sounds like it could be illusory. He's purporting to make a promise, but has he reserved a choice of alternatives? He has, right? One of them being, I'll paint the house. The other being, I'll do nothing, right? If I don't decide to paint your house, then he's pledging to do nothing, right? So he's given himself an out. So we have to ask, well, do each of those alternatives satisfy the element of consideration? Obviously, a return promise to paint the house would. That would be a detriment, right? That he would be obligating himself to paint Barb's house. But a return promise to do nothing, if I decide to do so, giving himself an out where he might do nothing, obviously that's not going to work to satisfy the element of consideration. So we would say, no, that doesn't work to satisfy the element of consideration. So not all the alternatives do, which means that this is an example of an illusory promise, and it would not satisfy the element of consideration because Barb made a promise, but it didn't induce a detriment from Bob. Why? Because he's not committing to do anything. He wanted the alternatives to do nothing. Let's compare that to this example. Barb, I heard you just opened a chocolate shop. Yep, right downtown. That's perfect. I will sell you up to 200 cases of chocolate bars over the next month, but you have to agree to purchase at least 50 cases. So Bob's promising to sell her chocolate bars. We'll see it's at $20 a case, and there's a range of possibilities here, right? 200 cases, but minimum order of 50. And Barb says, "Oh, I didn't know you sold wholesale chocolates. Just started. What do you say? 200 cases at $20 a case with a minimum order of 50 cases?" Well, okay then. It does sound like a good deal. I'm in. So is that a return? Is that a real promise, or is it illusory? That's the question we have to tackle. So let's look at our elements. She is purporting to make a promise, right? That yes, I will make an order from you for some amount of cases of chocolate bars. So we can say, yes, she's purporting to make a promise. Has she reserved a choice of alternative performances? Yes. And really, we could have a whole bunch of numbers in here, but at its extremes, it's maximum of 200 cases, minimum of 50 cases. So this is different, right? If we ask, well, do all these alternatives satisfy the element of consideration or not? Here, if she were just saying, I promise to buy 200 or I promise to buy 50, either one of those would satisfy the element of consideration. She would be incurring a detriment. She would be obligating herself to do something she wouldn't otherwise. So it's different than our first example where Bob's was saying, if I decide to do this, right? He gave himself an out. Here, the alternatives, which again could be way more than 1 and 2, could be the whole range between 50 and 200, but any of those would work to satisfy the element of consideration. So that means it's not an illusory promises because all the alternatives do in fact satisfy the element of consideration. So it's not an illusory promise. It does provide consideration. We have this return promise. We don't know the exact number, but we know at a minimum it's 50, at a max it's 200. So this isn't at all like the first example. So all the elements are met. Bob's promise induced a detriment. That detriment is why Bob made the promise to begin with, and Barb's return commitment to buy these cases of chocolate is a benefit to him and a detriment to her. So let's look at this example. Barb, I will sell you as many cases of chocolate bars as you need for your shop over the next year at a price of $20 per case. So now Bob again has made a commitment, but the quantity term is open, so to speak. It's measured in terms of Barb's requirements. Whatever she needs at her chocolate shop over the next year, that's what he's committing to sell to her. When Barb says, sounds good, count me in, we have to ask ourselves, well, is that a real commitment? Is she actually committing to order something from Bob? Or is this another illusory promise like our first example? So again, she purports to make a promise to commit to buy cases of chocolate bars from Bob. Are there alternatives she's reserving? One of them is that her requirements, her needs over the next year are some amount greater than 0. That's unspecified. But isn't one of the possibilities, one of the alternatives, that her needs for chocolate bars from Bob are 0? And if that's the case, it's much like the first example where she has an out, where she's not actually committing to buy anything from Bob, right? So if we ask, well, do all the alternatives satisfy the element of consideration? The answer would be, well, obviously, if she's committing to buy something more than nothing, than 0, yes, that would be true. But if she's given herself the alternative, my needs might be nothing, I might require nothing over the next year, then that wouldn't be a commitment. That wouldn't satisfy the element of consideration because it wouldn't be a detriment. She's given herself an out, which is to say that my requirements are 0. If that's the case, then we say, no, not all the possibilities, alternatives here would work to satisfy the element of consideration on their own, which means her return promise here would be illusory. So if that's the case, right, we would say Bob's promise did not, in fact, induce a detriment from Barb because she hasn't committed to do anything. She is saying, whatever my requirements are, they could be 0. So it would fail. But doesn't this sound like the kind of thing that people do in real life? So we need to ask ourselves, why is that? It's because there are two different bodies of law. And you're saying, what gives? You've not mentioned this before, and that's true. One of the bodies of law is the common law. It's summarized in the Restatement. The other is the UCC, or the Uniform Commercial Code. In particular, in contracts, our focus is on Article 2 of the Uniform Commercial Code. When we're talking about the common law versus the UCC, Article 2, we need to look at and say, well, how do I know which body of law I should be looking to? It depends what the subject matter of the contract is. If it's real estate and or services, then the common law governs. So if it's the sale of a home or a rental agreement, or if it's an employment agreement or a lawn service agreement or painting, something like that, then it's real estate or services. We look to the common law. However, if it's the sale of goods, then we look to Article 2 of the UCC. And you might say, well, what is a good? And what we can say, at least at this moment, is that we're talking broadly about personal property. And so it spans a range of things, all the way down to here's a big pen to here's an RV or an airplane. So there are many, many things that we buy day in and day out that would fall under the definition of a good, whether it's your laptop or your phone or the food you buy at the grocery store or at a restaurant. Those are all goods. We buy and sell goods all the time. And if we're talking about goods, we go to Article 2 of the UCC. What we need to understand is that the common law and the UCC sometimes are overlapping. What do I mean by that? Is that the UCC doesn't provide, for instance, like a specific definition of a promise or anything other than it doesn't give us a general definition of consideration. So we need to remember is that the drafters of the UCC said, well, it's only where we want to change the common law that we're providing a code provision. And so where there isn't a relevant code provision, we just fall back on the common law. And that's where there is overlap. But where there are differences is obviously where we're going to focus. And so under the UCC, remember the pink here is the UCC. We did some twisting. So now the top is pink and that's the UCC. An output or a requirements contract is in fact enforceable. Right? We just saw, though, under the common law, which is what we were viewing it through, and in this last example, we said, well, it looks to be illusory because Barb was not actually committing to buy a specific number. And in fact, she may end up buying none. So she had an out and it would be unenforceable. So historically, under the common law, the answer would be it's illusory. This kind of situation, this arrangement would not be legally enforceable. But the UCC says it is. So remember, we said under the common law, Barb's promise is illusory. However, under the UCC, it's not. Why? How is that? We would look at it this way. We'd say, well, Barb is purporting again to make a promise, which is to say, I will buy whatever cases of chocolate bars I need over the next year from you, Bob. Okay? That's the same as our analysis we did under the common law. Is there a reservation of alternative performances? We said yes, that she's saying whatever I require, which is a range of possibilities that we couldn't even specify the upper end, right? We know it's something greater than 0, but because one of the alternatives is nothing or 0, we said it's illusory because she may be committing to buy absolutely nothing from Bob. And the UCC says, no, that's the wrong way to look at it. Why? They say, no, there is a real commitment here. There's a real detriment. There's a real obligation here. Why? Because one, when Barb is agreeing with Bob to say, I will buy all the chocolate bars I require from you over the next year at $20 per case, that we're viewing that as a pledge that she is going to buy exclusively from Bob. So she's foregoing the possibility of buying those required chocolate bars from anyone else. So that in and of itself is a detriment, right? I'm foregoing the possibility of using other wholesalers to buy my chocolate bars. Then it's also, the UCC says, well, it's also in good faith. Well, what do we mean by good faith? Well, let's look at that. Good question. When we say good faith, here, if we're talking about a requirements contract, it's whatever Barb's actual requirements are over the next year. Now, I mentioned an output contract. That's just the flip side, right? It would be if the seller's saying, I will sell to you whatever my output is over the next year. That's called an output, right? It depends which side we're looking at. Are we viewing it from the buyer's side and saying whatever I require, or are we viewing it from the seller's side and saying whatever my output is? And either case, it's viewed as being exclusive, and that there is good faith that if we're looking at a requirements contract as was proposed by Bob, then there, Barb is saying, not only will I only buy from you over the next year, but also whatever my actual requirements are in good faith. So she's not going to say, oh, they're nothing when there actually is something. She's going to act in good faith. And related to that is the idea of, let's say she had provided an estimate to Bob of, this is what I think my needs will be over the next year, which makes sense that an estimate might be provided so that a seller like Bob would know, can I actually meet whatever the buyer's demands will be over the next year? Or also know how big of a commitment I'm making, can I take on other commitments? So those are all things that are important to look at. And what the UCC says is, when we're talking about orders, if there's an estimate, then Barb's requirements, her orders from month to month, cannot be unreasonably disproportionate with whatever estimate she provided. If there was no estimate provided, then her order from month to month cannot be unreasonably disproportionate to the history of orders that she's made over the last several months. So if for 3 or 4 months she's ordered only 20 cases, she can't all of a sudden come in and say, I need 2,000. Or if she's been ordering 50 cases for 4 months, she can't come in and say, oh, for the next 2 months there's 0. She can't give an order that's unreasonably disproportionate. And that is also sort of a moderating kind of good faith thing where there's an actual commitment that's being made. So there, the UCC comes in and says, no, this is a contract for the sale of goods. It's chocolate bars. A requirements contract is fine. We're not viewing this as being illusory. So there is a real commitment. Bob's promise is inducing a detriment where Barb is pledging to buy exclusively from Bob over the next year, whatever chocolate bars she requires for her shop. And she's saying, in good faith, I will do so, and my orders will not be disproportionate to any estimate or my history of orders from you. So the UCC says, Bob's promise induces a detriment, and that detriment is precisely what Bob was looking for, and that's a benefit to him and obviously a detriment to her. So it would work as consideration under the UCC. So moving forward, you want to have in your mind, when I am analyzing something on the front end, I want to ask myself, what is this contract about? Is it for services or for real estate? Then I'm looking to the common law. If it's for goods, then I'm looking to see, are there provisions of the UCC that may govern here that are different than what the common law requires? And we'll add to those list of UCC provisions that provide a different outcome than the common law. So this is the first of many, and I hope that's helpful. So until next time, I hope this has been helpful and enjoyable. As always, like and subscribe, and I'll be in touch with a few more lessons coming up about some more rules related to consideration, and then it's on to some other elements of contract formation. See you soon.